Welcome to this explainer. Today we're unpacking a story that, at first glance, is ostensibly about a really tragic altercation between two teenagers in Texas. But when you look beneath the surface, the trial of Karmelo Anthony is this profound, honestly kind of shocking look into the fault lines of our justice system. It asks a pretty terrifying question. How does the very makeup of a jury box shape the definition of reasonable fear? So we're going to begin in the immediate aftermath of a deeply polarizing verdict. The emotional toll here is just absolute. I mean, listen to the words of Andrew Anthony, reacting to the devastating realization that his 19-year-old son, Karmelo, is going to face 35 years in a Texas prison. He said, "Nobody wins. They did a number on us." For the Anthony family, the system, and specifically the jury selection, had completely denied their son justice before the trial even got off the ground. But on the flip side of that, we see the unimaginable grief of the Metcalf family. Jeff Metcalf, who is the father of 17-year-old Austin, expressed that while this verdict is definitely not going to bring his son back, it represents accountability. His words were, "He deserves what he gets." So you have these two families, right? Forever shattered by a single morning, viewing the exact same justice system through entirely different lenses. Section 1. A Tragedy in Frisco. The events of April 2nd, 2025. Well, to really understand the immense legal battle that followed, we have to first review the events that actually shattered these two families. The undisputed facts here center on a high school track meet. Heavy thunderstorms force a really sudden rain delay, and athletes are just scrambling for shelter. Karmelo Anthony seeks cover under a rival school's tent, and Austin Metcalf confronts him. What starts as a dispute over space rapidly and tragically escalates. It ends with Anthony using a 5-inch knife, fatally stabbing Metcalf once in the chest. Now, once they got into court, this single, chaotic moment split into two completely different narratives. The prosecution framed the whole thing as a calculated sneak attack, an unjustified murder by an armed aggressor. The defense, however, argued it was pure self-defense. They pointed out this massive physical disparity. Austin Metcalf was actually 50 to 60 pounds heavier, so they argued that Anthony, trapped and grabbed by a much larger opponent, reacted in a split second of visceral fear. Section 2. The Jury Selection Controversy. A Verdict in Question. So the climax of this trial wasn't just the verdict itself, right? It was the deeply controversial way the jury was actually chosen. To put this into perspective, Collin County, Texas is incredibly diverse. The white population there is roughly 48%. Yet, look at the math in this courtroom. To decide the fate of a black teenager accused of killing a white teenager, a jury was seated with absolutely 0 black jurors. None. How on earth does that happen? Well, during jury selection, a phase lawyers call voir dire, the prosecution used its power to remove 3 potential black female jurors. The defense immediately objected, pointing out that these women were basically identical in profile to a white juror who was actually kept. And the prosecution's official reason for striking them? They were educators. Yep. The judge accepted this reasoning, and the jurors were dismissed. Section 3, the Batson Challenge Explained, the 1986 Supreme Court ruling. This specific legal objection opens the door to a really fascinating historical mechanism designed to fight courtroom bias. At the heart of this entire debate is something called the peremptory challenge. If you've ever been called for jury duty, you've seen this in action. It's the tool lawyers use to dismiss you. Historically, attorneys could strike you for almost any reason whatsoever, without even giving an explanation, just to curate a jury they feel will lean their way. But there is a constitutional line in the sand here. Back in the landmark 1986 case Batson v. Kentucky, the Supreme Court ruled that striking jurors solely based on race violates the 14th Amendment. It established a pretty hard rule. You absolutely cannot systematically exclude people from passing judgment just because of the color of their skin. To actually enforce this, the court created a strict 3-step courtroom showdown. Step 1, the defense accuses the state of racial bias in a strike. Step 2, the prosecution scrambles to provide a completely race-neutral excuse. And Step 3, the defense tries to prove that excuse is really just a mask, a pretext for discrimination. Section 4, Step 3, Proving Pretext, the loophole in the law. Because it's right there in that third step where things get fiercely debated. I mean, comparing the original 1986 Batson case with the 2026 Anthony trial totally exposes how subjective this loophole really is. Back in the 80s, the prosecutor claimed he struck black jurors because they were young and might sympathize with the defendant. Fast forward 40 years, the excuse is that they are educators. Finding the line between a clever, valid legal strategy and hidden bias, that is an almost impossible task for a judge to do in real time. But the legal landscape is literally shifting beneath our feet. Just recently, in May 2026, the Supreme Court issued a major, game-changing ruling in Pitchford v. Kane. They declared that trial courts absolutely must give defense attorneys the explicit opportunity to argue that an excuse is a pretext. This brand new ruling puts a super intense, glaring spotlight on how judges are handling jury selection today. Section 5. The myth of race neutrality. What the data shows. Now, zooming out for a second, the data reveals that the Anthony case isn't just some courtroom anomaly. It's a reflection of a much larger system. Let's look at how self-defense laws actually play out in reality. A report by the Urban Institute found some terrifyingly stark disparities. White-on-black homicides are the most likely to be ruled justified under self-defense. Conversely, black-on-white homicides are the least likely. It really forces us to ask, are self-defense laws truly race-neutral in practice? And then there's this staggering finding from Duke University. They found that all white juries convict black defendants 16% more often than white defendants. But here's the critical twist. That massive 16% disparity, it vanishes completely when just one black juror is included in the deliberation room. Just one. It goes to show that representation doesn't just look good on paper, it fundamentally alters the outcome of a person's life. A Stanford Law report perfectly diagnoses exactly why this happens. In self-defense cases, the law asks a jury if the defendant's fear was reasonable. But reasonable is entirely subjective, right? It's often unknowingly tainted by cultural myths and unconscious bias. The laws themselves might be written without bias, sure, but justice is ultimately administered by human beings who carry their own lived experiences right into the jury box. Section 6. The ongoing legal battles, looking to the future. This brings us back to the present day and Karmelo Anthony's ongoing fight. This story is far from over. On June 10, 2026, Anthony's defense team officially filed to appeal his murder conviction. Legal experts are heavily anticipating that this appeal will zero right in on the Batson challenge. The appellate court is going to have to decide, was striking black educators a genuine courtroom strategy or just a thin veil for racial exclusion? So as we watch this incredibly high-stakes appeal unfold, it forces all of us to confront a rather uncomfortable reality. The laws on our books may be colorblind, but the people interpreting them simply are not. We really have to ask ourselves, can true impartiality ever actually exist within a legal framework that is so completely reliant on subjective human judgment? That is the question we're going to leave you with today. Thank you so much for joining us for this explainer, and keep questioning the systems around you.